By the end of this, you'll understand how a routine security line at a domestic airport became an arrest pipeline in the spring of 2026, and why the internal memo that authorized it was written so that no single agency's name sits at the bottom of the page. That memo is the reason a dozen attorneys spent April filing the same emergency motion in different courts. We'll get to who actually signed it. The answer is not the office everyone assumed. Start with the mechanics, because the mechanics are the whole story. When a traveler steps up to a TSA document-checking podium at a domestic gate, the officer scans a driver's license or a passport into a system called Credential Authentication Technology. CAT machines have been at checkpoints for years. Their stated job is simple: confirm the ID is real and the person standing there is booked on a flight. That's the version printed on the sign above the podium. The version described in the court filings does something else. According to a complaint filed in the U.S. District Court for the District of Nevada, sometime in early 2026, the identity data those machines capture began routing, in near real time, into a Department of Homeland Security records environment shared with Immigration and Customs Enforcement. Not the biometric photo alone. The name, the date of birth, the document number, the exact string of data that lets a system match a traveler against an existing immigration file. A person with a pending case.
A person with a decade-old order of removal they may not even remember. The match returns before the traveler has walked from the podium to the metal detector. Here's the part that turned a data question into an arrest count. The match, on its own, does nothing to a citizen. For a non-citizen with an open file, attorneys allege, it generated an alert. And an alert, at certain airports, meant officers were already positioned past the checkpoint. Think about where that puts the arrest. Not at the ticket counter, where a person could turn around and leave. Past security. Inside the sterile area, where a traveler has already handed over their ID, already committed to the flight, already been told by every sign and every officer that the hard part is behind them. That geography isn't an accident. It becomes the center of the entire legal fight. The first documented case that attorneys were able to reconstruct in full happened at Harry Reid International in Las Vegas.
A man in his 40s, identified in the filings by initials and case number, not name, because his removal proceeding is sealed, arrives for a domestic flight to Sacramento. He's lived in Nevada for 19 years. He has a pending application before an immigration court, the kind that's supposed to pause any removal. He scans his Nevada ID at the CAT podium. He clears. He's walking toward his gate when two men in civilian clothes, ICE credentials on lanyards under their jackets, stop him at the top of an escalator.
He isn't told he's under arrest for anything he did that day. According to his attorney's declaration, he's told there's an outstanding order in his file. The pending application that was supposed to protect him sits in a different system, on a different server, and the officers at the airport aren't looking at it. His checked bag continues to Sacramento. He doesn't. His lawyer finds out he's missing when he fails to answer his phone that night. It takes her 4 days to locate him, in a detention facility 2 states away. 4 days isn't a delay caused by secrecy. It's a delay caused by architecture. A person detained off an airport alert doesn't enter the system at the airport. He enters it wherever the transfer bus stops, and the intake record catches up hours or days later. She called the local field office, which had no record of him. She called the airport, which told her it only ran the checkpoint. She filed a locator request and waited. By the time the system produced his name, he'd already been moved once. That gap, the hours in which a detained person exists in no searchable place, isn't a bug the attorneys stumbled onto. It's the same diffusion of responsibility running through the entire story, expressed as a missing database entry. Now multiply that. This became a story
rather than a single bad afternoon, because immigration attorneys in different cities started comparing notes and realized they were describing the same event. Same choreography.
Same location, past the checkpoint, before the gate. Same detail. A client who'd cleared TSA and then simply disappeared into the concourse.
By late April, a coalition of legal aid organizations had documented dozens of these arrests. Las Vegas, Phoenix, Ontario, California, San Francisco International, Oakland. The Bay Area cluster is what pushed the story from immigration Twitter into the record of a congressional hearing, because 2 of the people arrested in Northern California had active, pending cases, the legal equivalent of a stop sign that the airport system drove straight through. The Ontario case is the one that made the pattern impossible to write off as coincidence. A construction worker, early 30s, initials only, flying to a job in Texas. His attorney had done the thing attorneys are supposed to do. She'd confirmed the week before that his case was open and his next hearing was months away. He scanned his ID for the flight. He was stopped between the checkpoint and the tram.
When she pulled his file afterward, the alert had fired on a supervision entry that had been closed for over a year. A stale line in a record no human had reviewed before the officers moved.
The match didn't read the file. It read a name and a flag, and the flag was old. That's the whole failure in a single arrest. A data point that should have been superseded, treated as current, because the pipe doesn't check for currency. It reads for a hit.
The obvious question is why a screener would be reading immigration status at all. That's not TSA's job. TSA screens for weapons and explosives. Its own mission statement says nothing about civil immigration enforcement. So how did a checkpoint officer end up as the first link in a deportation chain? The answer, according to the filings, is that the screener isn't reading anything. The screener scans the ID like they always have. The routing happens underneath, in the plumbing between databases, invisible to the officer at the podium and invisible to the traveler. That's what makes it efficient. And that's what makes it, in the words of one motion filed in the Northern District of California, a search the traveler has no way to know is occurring and no opportunity to refuse. Remember the memo. This is where it starts to matter, because the first thing every attorney wanted was a piece of paper that said this was allowed. They filed public records requests. They subpoenaed. And what came back was the strange shape of the thing. There was no single order titled Flag Immigration Status at TSA Checkpoints.
Instead, there was a data-sharing arrangement, an interagency agreement between components of the same department, DHS to DHS, framed in the language of operational efficiency and shared identity resolution. TSA and ICE both live under Homeland Security. Sharing data between them doesn't require a new law.
It requires a memorandum of understanding and a system connection. On paper, it looks like housekeeping. In practice, it rewired what a boarding pass check does. And the memo, attorneys noted, was structured so responsibility diffused. TSA could say it only scanned IDs, as it always has. ICE could say it only acted on alerts, as it always has. The database environment could be described as a neutral pipe. Everyone held one piece. No one held the decision. That's the design. We'll find out who actually put the pieces together, because someone did. And their name is in a document that took a lawsuit to pry loose. Consider the scale of what the checkpoint touches. TSA screens more than 2 million people a day across U.S. airports. The CAT machines process a large share of them. You don't need a high match rate against immigration files for the raw arithmetic to produce arrests every single day. You only need the pipe to be open. 2 million scans. a pipe that returns a hit on the ones with open files. The system doesn't have to be aggressive.
It only has to be always on. That's not a policy abstraction. That's a man whose bag lands in Sacramento without him. Now, the legal fight. Because this is where the geography of the arrest, past the checkpoint, becomes the whole argument. When ICE arrests someone on a street, in a courthouse hallway, at a workplace, there's a body of law about what the officers can and can't do. When the arrest is triggered by a scan the person submitted to in order to fly, and executed inside a secured zone they entered believing it was purely a security screening, the attorneys argue something different has happened. The traveler was compelled to hand over identification for one stated purpose, aviation security, and that identification was used for a second undisclosed purpose, civil immigration enforcement. Their motion frames it in constitutional terms. A person forced to identify themselves for security screening hasn't consented to an immigration status search. The government's position, laid out in its response, is that there's no separate search at all. The ID was voluntarily presented, the data was already lawfully held across DHS, and matching a name against an existing federal file isn't a new intrusion. Two readings of the same 40 feet of carpet between the podium and the escalator. The judge in the Nevada case does something that tells you how unusual this is. Rather than rule quickly, the court orders the government to produce the interagency agreement and the technical documentation of the data connection. Not to the public, to the court, under seal for review. The order itself is a small event, a federal judge saying, in effect, "Show me the plumbing." Between the podium and the seal order, the arrests keep happening. And this is where you meet the second documented case, the one that changes the political temperature. A woman flying out of San Francisco International, again identified by initials only in the filing, has a pending asylum application. Pending, meaning a court hasn't decided her case, meaning she's, by the rules, allowed to be present while it's decided. She scans her ID for a domestic flight. She's stopped past security. The officers are acting on a match to an older entry in her file, an entry the pending application was supposed to supersede. Her attorney reaches a member of the House within days, not because of who the woman is, because of what her case proves. If someone with an active, pending application can be pulled out of an airport line and detained, the system isn't distinguishing between a final removal order and an open case. It's flagging the name and letting officers sort it out later. And later is a detention cell in another state. You might think this was a routine enforcement action dressed up as a scandal. It wasn't. The distinction between a final order and a pending case is the difference between someone the law says can be removed and someone the law says can't yet be touched. When the airport system stops making that distinction, it stops being enforcement of existing orders and becomes something the orders never authorized. Here's the one thing worth saying plainly in this whole story. A pipe that flags a name doesn't know the difference between a closed case and an open one. It was never built to. And a system that can't tell the difference, running 2 million times a day, will grab the people it was never supposed to grab. The failure isn't a rogue officer. The failure is the design working exactly as designed. Which brings the whole thing to the hearing room. By May, the questions had moved from district courts to a congressional hearing, where the core demand was blunt. Who authorized the handoff? Not a philosophy question, a signature question. Members wanted the name at the bottom of the document that connected TSA's identity scans to ICE's arrest queue. The answers came back in the shape of the memo itself. Diffuse. A DHS official described the data sharing as consistent with existing authorities. Consistent with. Not authorized by a new order, permitted, the department argued, by agreements that already existed. TSA representatives emphasized that screeners perform no immigration function. ICE representatives emphasized that officers act only on lawful alerts. Each true, each incomplete, each one holding a single piece of a machine and pointing at the next agency.
One exchange in that room is worth slowing down on. A member asked directly whether a traveler was ever told that scanning their ID could route their name to immigration enforcement. The DHS official's answer was that the uses of DHS-held data are described in published privacy notices, the dense, rarely read system of records documents that live on a federal register page. In other words, disclosure existed, technically, in a place no traveler at a podium would ever look. That was the department's honest position. Not that travelers were told. That travelers could have found out if they'd known to go read the right filing before their flight. The gap between those two things, being informed and being theoretically able to inform yourself, is the same gap the lawyers were suing over, restated by the government as a defense. And here's the payoff, the thing the lawsuit finally pried loose. When the sealed documents were reviewed and portions described in later filings, the decision that mattered didn't trace to a cabinet secretary's public order or a signed policy directive with a face attached to it. It traced to a data governance approval, a technical authorization deep in the interagency plumbing that greenlit the connection between the credential system and the enforcement database. The document that turned airport checkpoints into an arrest pipeline was, in bureaucratic terms, an infrastructure approval, a permission to connect two systems. The person who authorized the deportation trap didn't authorize a deportation trap. They authorized a data link. That's the answer everyone spent 2 months chasing. It's also why it was so hard to find. Nobody looks for the origin of an arrest pipeline in a systems integration approval. The lawyers had assumed a policy. What they found was a plug. The aftermath is still being written, but the shape is clear. The court challenges forced at least a partial pause in some jurisdictions while the legal questions are decided. The geography of the search argument, past the checkpoint, is exactly the kind of clean constitutional issue that moves upward through the courts. Airports asked pointed questions about whether their checkpoints were now enforcement zones, a designation with consequences for how travelers move through public infrastructure. Lawmakers introduced language to require disclosure, to make the pipe visible to the person whose ID feeds it. And the uncomfortable fact, the one that isn't in any press release, the technical capability didn't go away. A pause is not a removal. The connection between a credential scan and an enforcement database is a switch, and a switch that's been built can be flipped again. The lawsuits are fighting over whether it should be on. The plumbing is already in the walls. Go back to the man in Las Vegas. 19 years in Nevada. A pending case that was supposed to protect him, sitting in a system the airport officers weren't reading. He scanned his ID because every traveler scans their ID. He did the ordinary thing. The system did the rest. His bag reached Sacramento that night, rode the carousel, and turned in slow circles until an airline worker pulled it off and set it in the room where unclaimed luggage waits for someone to come looking. He was 2 states away by then, behind a locked door, still holding the boarding pass for a flight that left without him.